Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. So the other day, someone sent me an email and they asked me specifically why I thought it was so important that an attorney be objective. Wouldn't I be a better advocate for my son or daughter in court than would be somebody who doesn't know them? And I explained that in some respects that might be true, but it also presents the possibility that I might present a type of case that was doomed to failure because of my own interest and blindness in the case. And since I want all my children to be immensely healthy and satisfied and have a wonderful life, I don't ever want to do anything that is going to impact that. So I just don't represent family. It's as simple as that. And one of the other reasons is because it has to do with negotiation. So I thought at the beginning here what I might do is explain how attorneys go about the process of negotiation, because negotiation is fundamental to what we do, and it's a very important skill for your attorney to have. And if he can't describe his process in negotiation to you, you probably need to look for another lawyer. You can find on here, I'm sure, 100 different videos about how to negotiate. And negotiation is truly an art form. It is a process. A lot of people think of it as a discrete incident, a negotiation, where party A sits down with party B and they, go at it. But that's not how negotiation truly works. Negotiation involves, first, information gathering. And you have to know what the other party knows. They have to know what you know. You have to be on an equal informational footing, or at least as close to an informational footing that's equal as possible. You're not going to know what their secret thoughts are, and they're not going to know what your secret thoughts are, but the bottom line is that you have a good understanding of the situation that brings the two of you together. The next thing that is important is understanding what your goals are. A lot of times people focus on a number when they are negotiating, and it's often unwise to do that. Thinking back to my other video about kindness as a litigation strategy, one of the things that I frequently ask for when I negotiate is an apology. I want an apology from the doctor. I want an apology from the hospital. I want an apology from the nursing home company, and I put that in my demand. I make sure they know that before we ever set foot in a mediation. I want them to know that I think this is important and it benefits them to do it. For one thing, it doesn't cost them a doggone dime to say they're sorry, and it reduces their exposure. A lot of times, I will also demand that they implement different policies. In a case we had in Oklahoma where the little girl developed hyponatremia, we demanded that they change their IV policies so that that kind of tragedy wouldn't happen again. These are the kind of things that you can do in litigation and in settlement that you can never get in a judgment. When a court issues a judgment, it says party A is going to pay party B $100,000. The court cannot order party A to apologize. The court cannot order party A to make changes in its policies. It can't do that because the only thing it can do, and the only thing that a lawsuit can do, is get you money. And as a result of that, you have far more range of possible outcomes if you think outside the box and you demand things that may not strictly be something you can get in a judgment, but that you can get in a settlement and that have value. Now, do they have cash value? No, of course not. You can't take somebody's written apology down to the bank and get paid on it. But what you can do is you can at least recognize the fact that they admitted what they did wrong. And a lot of times what happens in a lawsuit, particularly in a settlement, is the settlement document will say party A admits no fault in this matter. And I think that's probably a good thing, and I think insurance companies really like it when people don't do that, because they don't want someone to have a record of having admitted a certain type of fault. But if they apologize, again, that's not an admission of fault. It is simply an acknowledgement that they really are sorry about what happened in that particular case, and it does have some value. For those reasons, it is possible to negotiate along a continuum and not settle on a particular number. And it's important when you're negotiating to understand that you should care about the result, but not too much. I had this case involving an architect and a doctor. Doctors can be somewhat pig-headed sometimes, and they get stuck in their ways. They believe they're absolutely right, and there's absolutely no other take on this. And knowing that, it has an effect on how you negotiate. And the first mediation that we went through failed completely. And it failed completely because it happened way too early, before we had all the information available to us in the case. And as a result of that, we essentially didn't have the tools available to us to settle that case at that point. The doctor could have been on the hook for $50,000, but by waiting and going through the process, gathering all of the information that they had, giving them all of the information that we had, getting a third party involved, or a third party insurer involved, because there was a claim that they had violated the Consumer Protection Act, the architect had. As a result of all of that, we got to the point where at the end of the day, the doctor had to pay $5,000. He didn't want to pay $5,000, but it was a lot better than paying $50,000, and it always could have been more. So when you get stuck on a number and that kind of thing, that's what happens when you care too much. That's what happens when you're not willing to make a business decision and instead make an emotional decision. In negotiation, it has to be fact-driven, and it has to be one of those things where you realize that you're not going to get everything you want. They're not going to get everything they want, but you're going to deal with this issue and get it resolved. I think that's tremendously important because, again, negotiation is a process that is built on information, and when it works, and it works well, it results in a no-win situation for everybody. In other words, nobody can walk away saying, hey, I won. They can walk away saying, I got a settlement. And the other people can walk away and say, well, yeah, I had to pay a settlement, but I didn't have to pay as much. And the plaintiff says, yeah, I didn't get quite what I thought I would get, but I got them, to pay something, and that certainly means they've been held accountable. One of the things that lawyers do when they sit down with clients is they have to explain something that is a little hard for people to grasp up front. And that is that when you sit down to negotiate a settlement, for example, in a wrongful death case, poor John Doe, he got hit by a truck. He's not going to be there to see his grandkids graduate from, vacation Bible school, all kinds of things he's missed in his life, all kinds of things his family is going to miss. And so when you sit down to negotiate that, you are not negotiating over the value of his life or the value of their loss. You're negotiating over the value of the case. And every case has value, but it's important to be realistic about what value it has. Every state, almost every state, I guess, has caps on certain types of lawsuits, particularly in the areas of pain and suffering. I don't believe those are fair. I don't believe they're rational. I don't believe they're reasonable, but they are there. And because they're there, there is a top dollar that you could get if you were absolutely fantastically successful on your very best day. And that is not the number you are going to get in a negotiation. Now, you might get a jury to give that to you, and then you would get the opportunity to have the Court of Appeals or the Supreme Court take it away from you. So it is very important to realize that no matter what, you're not talking about the value of a human life or the value of a broken leg or the value of any other injury. You are talking about the value of an intangible thing called a lawsuit. And by virtue of that, you have to understand what the range of a reasonable outcome is. And you start at the bottom of that range. You start at the top of that range when you start negotiating. And if you're the plaintiff, and you stop at or near the middle point, and sometimes go a little closer to the end point, but you try never to take the smallest value. You always try to get them a little bit more. If you are on the other side, you realize that there's a maximum amount that you could be held liable for, which is, let's call it $2 million. But there's a really good chance that you could beat this whole thing and have to pay zero. Your starting position cannot be zero. And the reason it can't be zero is because if you're trying to resolve this case, the reason it can't be zero is because you could be hit with $2 million. So the value of the case is something more than zero, but less than $2 million. And based on the information that has been exchanged in between, you have the opportunity to figure out what your risks are. In a typical mediation, you might wind up having an expert come in and talk about their view of what happened. You'll have the lead plaintiff's attorney telling what his story is going to be to the jury and the things they think they're going to be able to get in. And then when the defense gets its turn, they're going to say, you're never going to get that in, you're never going to get that in. We don't think you have a snowball's chance of winning this lawsuit, but we're willing to offer something just to make you people go away. And eventually, you're initially this far apart, and sooner or later, you keep moving forward. Each of you makes changes, and then at some point, you reach agreement. That's how a negotiation goes. But it doesn't go that way if you negotiate emotionally. It only goes that way if you negotiate logically and rationally with an understanding that you are not dealing with the cost of a human life or the cost of someone's lifetime paralysis. What you are dealing with is the value of a case. What would the best jury on the best day give you, and what would the Supreme Court let you keep? That's why you need to have an objective lawyer represent you and not a family member. Because the family member gets wrapped up in this whole idea that you've been wronged, and they negotiate from an emotional perspective as opposed to a rational perspective. Now, almost every lawyer has been in a situation where the other person was that emotional individual, and their lawyer couldn't rein them in, or sometimes they and their lawyer couldn't be reined in, and it's necessary to go to court and whack them upside the head. That happens. But you never get anywhere if you go into it with an emotionally driven approach. So hopefully that explains a little bit better how negotiation works in the field of law. Why I think it is very important for lawyers to be objective and to give their clients good value by being the adult in the room and saying, we're not talking about Joe's life here. We're talking about what the value of this case is, and you need to kind of shelve the emotions right now. You are not making an emotional decision about the value of Joe's life. What you are making a decision about is the value of this case and what you hope to get out of it. And a lot of times we'll sit down before the thing and ask the client, what do you want to do with the money that you get? Well, I want to set up a scholarship. I want to protect my children. I want to make sure that they have plenty of income after I'm gone. Whatever that is, you then turn to those things and you say, look, you wanted to have plenty of income. The amount of money they're offering gives you that opportunity. It satisfies that goal. I understand you're not getting everything that you want and you'd like to get more, but at some point we have to be reasonable. We have to do the right thing. And again, lawyers, good lawyers, always do the right thing for their clients. And sometimes that means telling them inconvenient and perhaps even hurtful truths. And that's what our job is, and that's what we do. If you have any questions, leave them in the comments down below. Like, share, subscribe, all that stuff we ask you to do. Thank you so much for watching, and if you have the opportunity today, plant a tree or go read to a child, go do something that makes somebody else's life better, and you will, in that instant, make your life better. Have a great day. Catch me down here at the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.